Thank you all so much for joining us. We're happy to have you. I'll now turn it over to Greg to get us started.
Thanks, Megan. So this is the second of a two-part panel discussing immigration issues. And today we're going to change the focus a little bit to dial in on the personal experience of many of the changing policy issues that we discussed last week. Folks who work in the immigration field are fond of saying that it is a constantly changing legal environment. And apropos of that, this panel met about a week and a few days ago. And right after we met, we heard about the RAISE Act, which is endorsed by the Trump administration. It is a bill that would substantially revamp the U.S. immigration system. So, Rich, we weren't planning originally to talk about this, but tell us about the RAISE Act. What is it?
Well, sure. I guess, well, first off, Rich Stoltz with One America. I'm the executive director there, and realize I need to update my bio. So for the last 5 years, I've been the executive director of One America, which is a statewide immigrant advocacy and organizing group here in Washington State, with organizers in King County, Yakima, Clark County, and members throughout the state. And just briefly, a couple things that are important to understand about the RAISE Act, which is a bill being led by Senators Cotton from Oklahoma and Perdue from Georgia that President Trump announced that he supported. It's one of a steady stream of news we're all hearing every day on immigration-related issues coming out of the administration. It's important to understand a little bit about the context. From the perspective of immigrant organizations and advocates, there's been significant concern that while the president focused much of his attention on immigration, the rhetoric tended to focus very much on illegal immigration, naming immigrants as dangerous and as criminals, and focusing on Muslim immigration in particular. And so we saw the travel ban come out with regard to heightening concerns and fears within the electorate around Muslim immigration. And what we know that anti-immigrant organizations have been advocating for a long time hasn't just been to stop unauthorized immigration. The focus has been to limit legal immigration. And what the RAISE Act does is limit legal immigration through three primary channels. The first is to significantly reduce the cap on the number of refugees that the United States will allow into the country. It would eliminate the diversity visa program, which is one of the only mechanisms for many people across the country to actually make it to the United States if they don't have existing relationships of significance with citizens or other entities within the United States. The diversity visa program has been particularly important for some immigrants from Africa and other countries that are underrepresented with regard to immigration to the United States, and a newly proposed merit-based system. The merit-based system has been an ongoing fight for many years. In fact, back in 2013, a version of a merit-based system did find its way into a bill that did pass the Senate. The concerns about the merit-based system as it's been described and laid out in the RAISE Act is it would reduce the number of legal immigrants allowed in the United States and then eliminate a number of visa categories related to family members of U.S. citizens, focusing family immigration only on children and in some cases some parents of immigrants, and eliminating categories related to brothers and sisters and other family members and other relations. Instead, it would replace the family and current employment visa program with a new point-based system where, based on one's fluency in English, education level, ability to invest in the United States, and salary level, individuals would receive points that would qualify them if they were to receive, for example, more than 30 points to be allowed within the United States and to take up one of the smaller number of visas established by the law. So it's important to remember that much of our immigration system is complex and complicated as it is. there's a certain magic to it in the sense that, I remember researching and debating this years ago. Part of the magic of our immigration system is the ability to actually build communities here in the United States as families come together, as people begin the process of integrating into the United States society, economy, and culture. While there is much talk about the economic benefit of such a merit-based system, it's also the case that simply creating points based on these different categories doesn't actually match people to employment opportunities in the United States. From my perspective and the perspective of our organization, it's a very elitist approach to immigration policy. It doesn't actually address the economic needs of the nation, and it undermines the nation's commitment to family-based immigration. And it's concerning in particular because of the, frankly, racist undertones and that from which the bill originates, given the rhetoric and the language, not only of the presidential campaign, but of many of the organizations that have been advocating for this approach to immigration for quite some time. So that's an overview of the RAISE Act.
So Rich, just to return to a couple of those, you mentioned, the huge pivot that this represents away from family-related immigration to some sort of point-based employment and investment-driven system. So to the extent that this is responding to understood economic interests, one of the things we discussed on the last panel was the consistent need in Washington for agricultural workers specifically. See anything in that would respond to that need that's not just here, but elsewhere in the country as well?
No, and I think it's important not to make the mistake of believing that because they're talking about high-skilled immigrants that this bill in any way responds to the interests of business groups within the United States. This policy comes clearly out of the nativist camp within the Republican Party and other political entities that really have their focus on reducing immigrants, particularly immigrants not from Europe or Canada. And I think it's just important to realize that. There is no strategy related to the RAISE Act around the economic needs of lower wage industries. It's simply a strategy by which to justify the exclusion of many immigrants from the United States without meeting the economic interests of business or the country as a whole.
So one more question about the RAISE Act, and then we'll return to what we had planned to talk about. The RAISE Act contains an English language requirement for the points-based system, where it privileges English language ability. We've long had in naturalization law, which is the law of becoming a U.S. citizen, an English language test. But could you comment to the extent to which visas have been predicated on English language ability?
From my understanding, and being able to come to the country as a family member didn't necessitate being fluent in English, nor being given a certain level of points to qualify to come to the United States to be reunited with a loved one. And so I think it is a pretty significant shift, and it's important to understand that there's a difference between coming to the United States as an immigrant and naturalizing as a citizen.
Two different things.
They're very different things. So in this context, it really is a strategy to try to exclude people based on their likelihood of speaking English fluently.
I wanted to mention to those following us online, if any of you are Twitter users, feel free to follow the conversation at WA State Bar, and I'll be doing some tweeting as the conversation goes along. Megan, were there any questions?
We do have a question. Someone was curious if there are not unlimited work permits available for agricultural workers.
Great. Well, as the workaday immigration attorney, I'll just say, no, that's actually completely not true. They're capped annually, and there's no unlimited bucket to draw from for those, which is why we've had such consistent problems in eastern Washington. So Heidi and Anoka, let's travel to a United States port of entry like SeaTac Airport. Heidi, last week we spoke a lot about the travel ban from a policy perspective. But folks may not know that you led a huge effort to organize gigantic teams of volunteer lawyers to help assist people who'd been impacted by the travel ban. at SeaTac. Do you have any just kind of anecdotes from the trenches? What was going on there at SeaTac when the travel ban went into effect? What did it look like?
Hi. So when the travel ban went into effect, there was an immediate response of kind of several, probably 20 plus attorneys that just kind of crashed the airport in order to provide assistance to people who might be swept up in the inartfully implemented initial travel ban. And that day, I was part of the communication about where to go and part of the email string, and noted that there was a need to get people finding each other at the airport, that everyone was kind of talking past each other and there was no central person organizing where people should meet or, making sure there was good coverage. And so I kind of just hung back and spent the evening on my laptop with that email string, another email string, Twitter and Facebook with a couple of different pages, and kind of tried to help facilitate people meeting up down at attorneys, interpreters, and other service providers meeting up among the insane protests that were happening simultaneously with this. So that next Monday, we had identified a need, that there was going to be an ongoing need for assistance to people down at the airport, and that just using a chaotic approach where people just showed up when they had time wasn't really going to help anyone. It wasn't going to be a good use of professionals' time. It wasn't going to ensure consistent coverage. So my law firm, Lane Powell, supported us kind of leading the charge to organize people volunteers down at the airport. We worked with firms throughout the city, and both solo practitioners and leaders in immigration law and pro bono leaders at various law firms, to come up with a way to staff the airport. We identified the hours of coverage that were needed, and then made sure that we had access to interpreters, attorneys. We had law students that volunteered, paralegals, legal assistants by the end. And so we had consistent coverage for flights, which usually was about 7 a.m. to 3 to 6 p.m., depending on that afternoon flight. And so that first weekend was very chaotic, as it was throughout the country, because the Customs and Border Protection didn't really have any guidance as to whether people with valid visas should be stopped because all of a sudden the rules had changed, or let through. And so there were a couple people that got lost at the very beginning back in Customs at SeaTac. But after that first weekend, and because we had people consistently at the airport standing at the top of the escalator where people come out from Customs, we didn't lose anyone again. We had people that were stuck in the secondary inspection area in Customs for, I don't know, hours at a time, but then we had ways of figuring out what was going on, and in every instance that person came through and was able to reunite with their loved ones. So we had, crazy communication between volunteers at the airport, volunteers with airportlawyer.org, which was a great resource that Greg actually was instrumental in putting together. We were always able to kind of get our hands on why the person was delayed in secondary and finally bring them through.
So Heidi, our audience might say, well, the travel ban, that was really tough for the people it impacted. That I can imagine how if you're a Syrian refugee and you're in the air when this policy gets passed and you get at the airport and things are chaotic, that's terrible. But what about for those of us who maybe were already United States citizens, or were green card holders, or we have a lawful visa? What rights does such a person have at a U.S. port of entry?
So there's a few things that Customs and Border Protection are just allowed to do. They're allowed to stop, detain, and search any person or item at the border or in Customs. And Noka will talk about this, but there's some dispute over their rights as to accessing electronic devices. That's a little bit, it's currently contested. They're allowed to ask about your immigration status at the time of entry or departing the U.S., and they're required to obtain fingerprints. So if you enter into the United States, you are required to provide fingerprints, whether when you're getting your passport or getting your visa, entering the United States. Customs and Border Protection may not select people to search based on the usual parameters. They can't base it on race, religion, national origin, gender, ethnicity, or political beliefs. If they questioning individuals about their religious and political beliefs infringes on rights guaranteed by the Constitution and federal law, which you do not surrender at the border. So citizens have the highest level of protection as to those, but lawful permanent residents and even non-citizens have some rights when it comes to those topics. I can just go through real quick. If you're a U.S. citizen and you've presented a valid passport, you do not have to answer a customs officer's questions, although refusing to do so could secure you a longer stay back in customs.
Or a very short stay in the United
Or a
States.
very short stay, right.
0 minutes.
Right. So refusing to answer routine questions about the nature and purpose of your travel could result in delay. But you do not have to answer questions about your religious beliefs. You do not have to answer questions about your political beliefs. And you cannot be denied entry to the United States for refusing to answer those questions. If you're a lawful permanent resident and you're pulled back into secondary inspection, it's generally recommended that you answer questions. But again, you may decline to answer questions about general questions about your religious beliefs and political opinions. But again, doing so may delay may lead to delay or additional questioning, and potentially denial of your entry into the country. If you are a lawful permanent resident, do not sign anything when you're back in secondary, because there was some talk at the beginning of this travel ban that people back in secondary who had green cards.
What's secondary inspection?
Oh, sorry. Secondary inspection is where, when you're in line at customs, there's the routine just pulling up your passport and asking you questions. If they want to ask you additional questions, they can pull you back into what's called secondary inspection, and it's a separate room where you're basically in a conference room, and they can take away your cell phone. I don't believe there's a requirement to provide food and water. I mean, people were being denied those things, although that's a basic kind of human right. And so back in secondary, there were tales of people who had green cards and visas being given a form and saying, listen, I'll let you out of here, but you have to sign this. And in many cases, these were given to people who did not read or even speak fluent English, and those forms were on those forms, by signing them, they forfeited their green card or their visa. And so that's a big thing, is just don't sign anything, even if it means you're going to be back there for several hours. Better to be back there and emerge with your rights than to forfeit your green card or visa.
Let me look for some validation from Lieutenant Diaz here. So people might be familiar with the relatively restricted rules that govern when a police officer within the United States can make contact and the scope of that contact, what it can be. Is it fair to say that we're talking about something that's way, way broader than that?
It's a lot broader than that when it comes to federal. So, I mean, for us, it would be similar to like a Terry stop, or under the case of Terry v. Ohio, reasonable suspicion and what we can and can't do, what we can ask, and whether it's a social contact or if it chances over to a Terry stop. So, for us, we would have to have reasonable suspicion, and this is a whole different parameter.
Seattle police can't simply make contact with somebody and have an indefinite interrogation of them on the spot with no reason. Whereas at a U.S. port of entry, it's basically sky's the limit in terms of what can be asked of you, with very limited constitutional exceptions.
Correct. And then for non-citizen visa holders, so people who are coming either to present at a conference, here on vacation, to visit family, refugee entry, they can be denied entry to the United States because for answering by refusing to answer a Custom and Border Protection's questions.
Right. You never have to answer unless you want to get into the United States.
Right, exactly.
Well, let me bring Anoka into the conversation here. So let's just make it the cleanest cut case and say you're a U.S. citizen returning. As a U.S. citizen, you have a certain legal right to return to the United States, but you got some stuff with you. Maybe you've got your computer, you've got your bag. What sort of protections do you have of your physical stuff, but also of your electronic devices? Because you might have client information on those devices. You might just have intimate personal information that you don't want examined.
Great. Well, so my name is Inoka, and I'm with the ACLU of Washington. And we seek to expand and enforce the rights of non-citizens because we know that when one group, one vulnerable group in our population is targeted, then we know that impacts all of us. And I feel like this is a pretty clear case where, this is sort of the first time in a long time where so many U.S. citizens have been reaching out to the ACLU and saying, what are my rights at the border? I thought I'm a U.S. citizen. How can I not be allowed back in? Do I have to give up my passwords? Can they search my laptops? Can they search my cell phones at the border? And as Lieutenant Diaz mentioned, if you have a cell phone or a laptop with you, a police officer can't just search it. They would have to get a search warrant under our Fourth Amendment. The U.S. Supreme Court has said that. But the federal government's position when it comes to airports and the border is that the Fourth Amendment doesn't apply to border searches. And you're right, Greg. It's one thing when you're looking at someone's bag, but when you search someone's phone, it has intimate, personal, confidential, private information. It has financial information. It has, if you're a reporter, it has protected confidential sources. It may have privileged attorney communications. And so our phones and our laptops are a place that we often, I think, the average person considers to be very private. And in the Ninth Circuit, which covers the West Coast, and where Washington State, of course, falls in, there is actually a Ninth Circuit case that says that Customs and Border Protection, CBP, that they have to get a search warrant in order to look into your laptop and your cell phone at the border. And it's sort of on a limb. It's the only circuit that's ruled that way. But I recently spoke with a CBP director here based in Washington State, and she wasn't very familiar with the case, and she still maintains the position that the government doesn't need a warrant to search your devices. And because these agencies aren't as transparent as they should be, we don't know how many of these device searches are happening at SeaTac or Washington State. We know that in general they're increasing exponentially, actually. And so the government can ask you, the CBP during customs, they can ask you to see your cell phone or your laptop. They can ask you for your password and unlock your phone or your laptop. They could do a cursory search, which is just looking at your device there, or they could download the data and search it later. They could also do what's called a forensic search, where they actually take your device from you, and they can hold it for days or weeks. Although once they give it back to you, they're supposed to delete your data after 3 weeks. And so if you're a U.S. citizen,
Not from your device, but from the stuff.
From their possession, they're supposed to delete the data that they took from your device. If you're a U.S. citizen, as Heidi mentioned, you do have a right to say no and to refuse a data search, but that will likely result in you being detained or going to secondary inspection and being detained for longer. For green card holders, similarly, you do have a right to enter the country, and your LPR status can only be revoked by an immigration attorney. I'm sorry, by an immigration judge. Not an immigration attorney, immigration judge. But for green card holders, you should definitely check with an immigration attorney before traveling to see whether taking that risk is worth it, whether you might have other issues in your particular case that would allow them to, have you sign something and deny your entry. And as Heidi mentioned, also, if you're a visa holder or from a country where you don't need a visa, like Europe, for example, or Canada, then they can deny your entry if you refuse to give them your password or your device.
Tell me if this is a fair summary for our audience. So, returning U.S. citizen, you can't be refused entry. regardless of what you do in regards to your electronic devices. You don't have to give your password, but if you don't, you might lose your laptop or cell phone, at least temporarily.
Right.
And that might be searched elsewhere.
Yeah.
And an additional protection may be to just, and when you enter, to have all of your devices powered down, because there's some question as to whether they can make you
Right.
power it up, and particularly to disable the fingerprint lock, because it's unsettled whether they can require you to put your fingerprint on and therefore unlock the phone.
Yeah, there are some tips for traveling.
Yeah.
The first is just to travel with as few devices as possible on in your carry-on. And then, as Heidi mentioned, turning off your phone, and if you just can't bear to do that, to put your phone in airplane mode. There is, within their own regulations, they're not supposed to CBP is not supposed to access data that's stored on a remote cloud. And so having your phone in airplane mode will help to reinforce that. If you are asked for your password, it's always advisable to enter it yourself rather than giving the government your password. If you do that, then be sure to change your password as soon as you can after you get your device back. If your device is taken from you, be sure to get a receipt for that device with contact information of the agent who has it, and also with your cell phone information. And also, as a precaution, to just back up your data and your on your cell phone before traveling. There's also, in terms of advocacy, what we can do is that there is legislation in front of Congress right now. It's called the Data Act that would require CBP to get a warrant before searching devices. And so one thing you can do is to call your representatives in D.C. and show your support for the Data Act.
And to put a plug, ACLU has great resources on the national website, kind of know your rights, thumbnail cards, although the advice isn't always what you might want to hear because
Right.
the scope of search is very broad.
Right. And we have some Know Your Rights cards in English and Spanish that are based on Washington law, so additional protections for here.
And just before we leave this topic, if you or someone that you know is entering the country through, in particular SeaTac, but also several other airports, there's a resource which, again, Greg was instrumental in creating called airportlawyer.org. And on there, you can report all of your flight information and all of the information that that attorneys volunteering for that particular port of entry would need in order to be there in case you have an issue. If there's a particular issue, potentially have you fill out forms so that you would have the right to, you'd have the necessary forms in order to have an attorney come back and represent you in secondary inspection if it becomes necessary. And generally just someone knows you're coming in so that if you do not come through customs, we have the resources to find you.
Thanks, and that's airportlawyer.org, free resource. Yeah, question.
Yeah, quick question. You said that
Hold on,
the tip
Tommy,
would be
1
to...
second. There you go.
Thank you. Your tip was to carry as few items in your carry-on as possible. Does that mean that you could check a laptop more safely and there's different protections, or just less likely that they're going to sweat you?
They will still have the right to search your luggage, and if they do a forensic search or they take your laptop from your luggage, they would have to show you that and give you a receipt. But I think it's a precaution you can take. It seems to be less likely for that to happen. We know that in 2016 there were 5,000 device searches, and within the first 3 months of this year there were already 5,000 searches. We know that CBP at the border in person is that those contacts are increasing, and we haven't, at least I haven't heard the same for things in checked luggage.
The other thing to be aware of is the laptop travel restrictions that have been implemented. So before you travel to really anywhere internationally, you should check with, I think it's TSA probably, that has the information on whether the location you're going to has some kind of restriction as to laptops or tablets.
Well, let's switch gears entirely here.
Sorry, one thing I wanted to mention is that since we aren't getting information from the CBP office here in Washington State, if you or anyone you know is subject to a device search at SeaTac, please let us know. Get in touch with the ACLU in Washington. There's also a form you can fill out at the National ACLU office. website that goes into sort of a form about what your experience with that device search was like, so we can enforce our civil liberties. And
So we've been at the U.S. port of entry. Let's come now into the United States and to downtown Seattle. And I think there may, Lieutenant Diaz, be confusion in the general public about this generally. What role does SPD play when it comes to immigration law? I mean, it's federal law. We're all beholden to federal law. Don't you have to enforce federal law?
Yeah. So roughly there's about 800 to 1,000 bills throughout the country that are related to some sort of immigration. And about a fifth of those bills are going to end up involving public safety or having local law enforcement involved in some level of immigration enforcement. I've been around since 20 years. And so since that time, 287G was at the very beginning of my career. After that, we moved into secure communities. So when I made an arrest, if I took them to King County Jail's databases might end up having that link up to the federal immigration and could send detainers down there. Now, we had because of our local values, in 2001, the Seattle Police Department enacted a policy that said that we would not ask immigration status. That was ratified in a city ordinance, I think in around 2003, that allowed us to make sure that if officers did, it was ratified in law that officers, would have some level of accountability to that to that end. And around locally, after secure communities came around, even the King County officials realized like that was not an area that they wanted to go, and also ensured that they set out policies to make sure that they weren't engaged in that process of communicating with ICE or Immigration Customs Enforcement and accepting detainers for people, whether, for example, if I made an arrest for DUI and I did take them to the King County Jail, that detainer could be placed on it. Now, King County officials actually changed that and ensured that they wouldn't honor those detainers that could come down.
So just people might not be familiar with secure communities. Is it fair to characterize that the policy decisions being made here were let's keep enforcement of criminal law separate from enforcement of immigration policy and have SPD focus on the first of those?
Correct. And so in this process, there's actually right now, Texas is actually experiencing, I think it's SB 4, which is saying that even if a department decides that they're going to create a policy to ensure that officers don't ask it, it would be actually against the law for that.
Precisely the opposite of Seattle.
Precisely the opposite of Seattle. So, so you have this torn where the officers are getting torn in a variety of different areas. So really what you're focused on is ensuring that the department's values are mirroring what the city's values are. And for us, it's about working with our community. It's about building trust. It's about building that connection. So it's more important for us to have people report crime. And if you look in those areas, even LA or even in Texas, there's some of these agencies that have actually saw like 20 to 30% decrease in reporting of crime based on this push on immigration enforcement. So that was not something that we wanted to do or experience. So we really tried to get out information about how we really want to focus on building trust and connection, and that we are not going to ask immigration status. But that doesn't mean that we don't have challenges with the system, because, for an example, if an officer goes and makes contact with somebody, during the process they run the subject's name, and that person has a warrant, it is very difficult for that warrant to determine whether it's an administrative warrant that is issued out by HSI, which is Homeland Security, which is ICE is a product of Homeland Security. It's difficult for the officer to say, oh, this is an administrative warrant or this is a criminal warrant. And how that might play out, such as a rule is that HSI might issue a warrant out for human trafficking. And so it's a criminal nature warrant. Officers would go out and say, oh, we need to enforce this because human trafficking is a product of victimizing our community. We'd want to make sure that our community is safe. So if we saw a warrant, we'd want to ensure that we arrest on that. However, it's very difficult to determine whether it's an administrative signed by a judge, or if it's going to end up being a criminal in nature, to determine whether it's a human trafficking.
And when you're talking about administrative warrants, what are you talking about there?
So if somebody is just here in the country and they say illegal, I apologize, illegally, then that would be an administrative, that doesn't have their papers or isn't documented, and so that would, to us, be an administrative warrant.
So the SPD officer has run the plates, warrant comes up, he doesn't know if this is a serious criminal trafficking investigation or if it's somebody who's unlawfully present in the States, perhaps, and has a non-criminal
Correct.
issue.
It would be very difficult for us within a couple of minutes to determine which kind of warrant this actually comes from. To us, it's a warrant, so the officer is making an arrest, and then what we have is like later on determining, oh, well, this is an administrative warrant or this is a criminal in nature. So that makes it very difficult for the officer on the scene to actually determine what they're going to end up doing, which breaks trust in there, because then it's, oh, you're actually enforcing a certain law that I thought you were talking about building trust. And then the other piece in there that makes it difficult is whether the warrants are actually being purged properly out of the system. So if somebody that has been going through a court hearing through the proper channels, working on their immigration status, but they might get a warrant issued because they didn't show up to court, whether that warrant is now being purged properly out of the system when they go to the next administrative hearing. And so for us, it's very difficult for us to determine that. What we do is we call up and validate the warrant, but it's not sure if the actual warrant was actually done properly and purged out of the system. So which makes it difficult.
This is on the offender and potential offender side.
Correct.
On the other side of the coin, what happens when an immigrant victim, crime victim, contacts SPD?
So that's a little bit, for us it's a lot easier. So if you're a victim of a crime, what we're going to end up doing is we're not asking immigration status, so we're going to take this and process it like a general offense report. We're going to investigate it with no issues in there. If you're a victim of a violent crime and you fit the criteria for I apologize,
U-Visa.
U-Visa. Then you would actually go through that process. The process goes through our legal unit, so all of the case reports that would meet that criteria would go through our legal unit. They would sign off on it for somebody trying to establish their U-Visa with our department, our U-Visa through the process of the court.
So just a quick side note there, a U-Visa is a special type of visa under the Immigration and Nationality Act that benefits qualifying crime victims to encourage them to contact law enforcement and be in the system.
Exactly. And not every crime is going to fit under the U-Visa criteria. It's usually typically violent crimes. In there, sometimes it is domestic violence, sometimes it is shootings or other different types of incidences. So,
no, obviously you're speaking for SPD. Our audience is outside of just Seattle. To what extent is that practice that you just described of, we treat immigrant crime victims just like any other crime victims, how consistent is that in other areas of our state?
It's all based on department policy. So any department can have locally, typically in the area of King County, everyone kind of has this very similar policy to what we have as far as not asking immigration status. But other agencies can have actual immigration enforcement actually work out of their offices as well. And I do know in this region that there are a couple agencies that do have that in occurrence. But for us in King County, we really try to make sure that we're building that trust within our communities. And we have enough issues already at hand. I mean, we're dealing with last year alone, we had 10,000 calls for people in crisis in mental health. We have a lot of other issues in trying to ensure that officers are going through a variety of training. We've actually upped our training by like 6-fold, but we're trying to up our training in areas of de-escalation and use of force. So we're not worried. We're not trying to worry about immigration. We're trying to build our trust within our communities to have that better working relationship.
You're not looking for extra work in new areas of law to enforce.
Exactly.
Lieutenant Diaz, thank you very much. And I just want to keep us moving so we can cover our last two topics. At the end of the discussion, I'll be asking each of you to share perhaps your leading thought that you'd like the audience to be left with. And Noke, Real ID Act is something that we hear a lot about in the immigration law community. I'm not sure that the broader public is super aware of it. What is it, and how is it being implemented in Washington State? And we'll keep this part relatively short.
That's a great question because it's going to impact really everyone who lives in Washington State who wants to drive. But there's a federal Real ID Act.
Nobody wants to drive in Washington State anymore.
There's a federal Real ID Act that was enacted in 2005 in response to, as a recommendation from the 9/11 Commission, and it set national standards for security of state-issued IDs, and it prohibited federal agencies from accepting non-compliant state IDs, and it also required that non-compliant state IDs are marked as being non-compliant. So in Washington State, we currently have two kinds of driver's licenses. We have the enhanced driver's license, which is called the EDL, and then a regular driver's license. And the EDL complies with Real ID, and because Washington's EDL allows us to travel to Canada and to Mexico across the land border, it requires U.S. citizenship. So only U.S. citizens can apply for and get the EDL. And the regular driver's license is not compliant with Real ID, nor is it marked to say it's non-compliant with Real ID. But anyone who's eligible to drive can get this. So green card holders, undocumented folks, people on visas, and of course U.S. citizens. And so currently both driver's licenses allow us to drive, and both allow us to go to SeaTac, go to the airport, and get onto a domestic flight. But so earlier this year, the Washington legislature passed the Washington Real ID Act, which would bring our state into compliance with Real ID, with the federal Real ID. And the feds have said that starting in January 2018, which is really soon, that you will no longer be able to use your regular driver's license to get onto a domestic flight in the U.S. And so you have to either have an EDL or you have to bring your passport. This will likely be extended to October 2020. So, and that's, I think, what the Department of License is hoping as well, because we're not really hearing much about it. But we're hoping that deadline will be extended. But so far, that extension hasn't been granted. And so the Washington Real ID Act, one of the provisions is that starting in July 2018, so about a year from now, all the regular driver's licenses will be marked as being non-compliant. There's still a lot of questions around Real ID and its implementation. The Department of Licensing hasn't sort of shown us what a marked license is going to look like yet. And so we don't know if it's going to just sort of be subtle or if it's going to be sort of like a scarlet letter, whether it's going to be very clear who is a U.S. citizen and who has this marked license and is in a pool of people who are non-citizens. We also don't know what's going to happen to people who currently have unmarked regular licenses, like myself. Like I just renewed my license in January. It's good for 6 years, but it's not marked, so it's not going to be compliant with Real ID for 6 years. And so we don't know what's going to happen to those IDs. DOL might sort of require that everyone renew their license after these marked licenses are available. Some of the things that we're concerned about, and that a lot of immigrant folks in the immigrant community are concerned about, is that there in the legislation it says that police officers can't use a marked ID to discriminate or to treat someone differently or to assume immigration status. But we don't know if private actors will use a marked ID to discriminate. So, for example, a bartender could be like, oh, I'm not going to serve anyone with marked IDs. Again, that's something that if you hear about that happening starting in July 2018 when these marked licenses are available, please contact the ACLU. That's something that we are really concerned about. We also don't know in terms of the DOL's databases. They're going to have a list of people who have these marked IDs, and if that pool is really just going to be non-citizens, then the ICE and other federal agencies can always access that database. So we don't know how ICE will use this information to target non-citizens for deportation. So we have a lot of people who are undocumented who wonder, should I go without getting a driver's license? But that's also concerning because it's illegal to drive without a license, and that's a crime. And we know that ICE looks at arrest records. And so what ends up happening is that it's really a tough decision if you are undocumented. And whether you're undocumented or a green card holder, starting in either January 2018 or October 2020, you will have to bring your country's, your passport from your home country when you travel just domestically in the United States. And so for people who are undocumented, that is risky because you may not have a visa in your passport. And so even though it's just meant to be a check on your identity, there's always a risk and a concern that actually, that will be used to sort of fuel deportation.
Cheery note. A basically unrelated side note, but for folks who aren't aware of it, since we're here in Washington as a border state, if you haven't heard of the Nexus Pass and you're a frequent traveler to Canada, definitely look it up. It basically puts you in the express lane at the port of entry going up to Canada, and also puts you in the express lane at the airport, even for domestic travel. So I think it's a travel hack that not everybody knows, and as a frequent traveler, I can't recommend it highly enough.
And one thing that, in terms of advocacy that we can do is that if you are a U.S. citizen, that you can really be an ally and opt out of the EDL so that that pool of people with marked regular licenses will be bigger. And that all that means is you'll have to bring your passport when you travel, anytime you go to the airport. But it's one way to help protect our fellow non-citizens in Washington State.
And Megan, we'll have to make this real quick.
Yes, one question from the audience, please.
Sorry, is the motivation for this whole thing just so that non-citizens can't fly and travel?
Well, the original motivation of the Real ID Act of 2005, I think it was to create security standards. And the Washington State legislature's motivation to comply with Real ID is that we've been non-compliant for over a decade. And we are facing threats from the federal government around travel and access to airports, but that is certainly a byproduct of it. That it will make it very difficult for people who are not citizens to fly even domestically.
Rich, the last thing we wanted to touch on was your thoughts about, for those who are out there in the community, our audience, who are worried about what they're hearing and have concerns about the direction of immigration policy. It seems really confusing and big and national. What would you suggest people do to get involved in issues that they're interested in? And folks, I'm going to have this kind of dovetail into giving you each about a minute and a half to share your closing thoughts. So, Rich, you can merge those two together.
Sure. So it's a very complex political environment, constantly changing. My advice to folks who don't intend to get into the weeds of immigration law or policy is to get back into your own personal immigration story, your family's immigration story. Step back into that place of values and what are the values that really matter to you, and stay there, stay focused there. Communicate it. Make sure other folks understand it, because much of what is going on here is sort of a battle over, the soul of the country in some ways with regard to its immigration policy and who belongs. But more tangibly, I'd also recommend that folks consider donating, volunteering, and advocating. So there are a number of wonderful organizations throughout Washington State. One America just happens to be one of them, doing excellent work in communities, organizing, advocating, providing direct services to immigrants, including Know Your Rights trainings and other kinds of services to equip immigrants with the skills, tools, information, resources they need to navigate the current political environment. Volunteer. We heard about the attorneys. I went to the airport. I think there are still more attorneys volunteering on a regular basis through naturalization clinics and helping people to become naturalized citizens. In some ways, becoming a citizen is your strongest protection if you are a legal permanent resident and are eligible to naturalize. Participate with organizations and Know Your Rights trainings. Get information out into the community. And with regard to advocating, at the federal level, make sure your representatives know where you stand. They need to hear about your values, how you view immigration policy, and what really matters to you. At the state level, there is important work to do to figure out what the state can do to respond if, for example, policies that provide some relief to categories of immigrants like dreamers, folks who've come here as children and have known no other home but are undocumented, currently have a sort of temporary protected status through something called deferred action for childhood arrivals. What happens if that goes away? What is the role of the state in that context with resources, et cetera? And then at the local level, here in Seattle, Seattle just passed a bill and funding for a legal defense fund for immigrants facing removal proceedings. Tacoma is considering something similar. Local jurisdictions throughout Washington State have codified policies around police not asking about immigration status. And there are many other tools that can be used in that context. And there are coalitions that have emerged just in the last few months, like the Washington Immigrant Solidarity Network, to provide those kinds of services, coordination around advocacy, the Justice Advocacy Network that is looking at the intersection between immigration, advocacy, and criminal justice reform, and many other efforts that folks can learn more about by contacting folks on this panel or going to the One America website.
Rich, thanks a lot. Lieutenant Diaz, in 60 seconds or less, closing thoughts.
We have a lot of challenges when it comes to public safety, and one of the biggest things is building trust in our communities is essential. I mean, if people don't feel comfortable talking with the police and reporting crime, we can't figure out ways to address public safety issues. So I really want to just reiterate making sure that your departments are, throughout the state or throughout the country, are really focused on ensuring that the community feels very comfortable in talking with them and opening up about issues that are going on so we can all work together on addressing public safety issues. So just focus on building trust.
There is a lot of misinformation right now, and there's a lot of fear, and I would just encourage everyone to remember the facts. There are studies that show time and time again, even from the Cato Institute, that non-citizens actually commit crime at lower rates than citizens. And so we can use facts and we can use our values that we've been speaking about to make sure that Washington has a limited role in enforcing federal immigration law, and that we support and protect the rights of all of us living here in Washington.
I would just reiterate everything that Rich was just talking about and add that anyone can get involved. You don't have to have a particular expertise. One thing I found through the airports is you don't have to have a particular expertise. I'm a bankruptcy attorney that became a key part of the fight to keep our refugee and immigrant communities safe through that travel ban. So even if all you can do is call your representatives, it takes 5 minutes. Donate money. Many of the organizations out there that are working in this space can use a variety of talents, and everyone has something to offer. So I would just encourage people to get involved however they can.
And I do want to thank folks for their interest in attending or watching the recording of this. The mere fact that you've devoted an hour to exploring these issues really says a lot and speaks to the commitment that our community has to doing well on these issues. Thanks to all four of you. The audience probably can't possibly appreciate how busy immigrant advocates are in these times, so thank you very much for the time. Megan, thanks to WSBA for its attention to these issues. Do you have any concluding remarks you want to make about future Decoding the Law series?
I do. Thank you so much for that plug. Decoding the Law is a quarterly program, and our next topic is going to cover education, ideally sometime in the beginning of October. Please look for additional news on that, and thank you all so much for tuning in. And a big, big thank you from the WSBA to all of our panelists. We could not do it without you. And
if folks want to connect with any of the panelists, I believe their contact information will be on the Decoding the Law page, or at least the panelists' names will be.
We don't tend to publish their contact information, but something tells me if you Google any one of them, you'll probably find them.
We're all on the Google. Some of us are on the Twitter, too.
That is true. Thank you all so much.
Thanks, everyone. Have a great week.